A big decision was recently handed down from the Supreme Court overturning the Chevron Doctrine. It's a decades-old ruling around federal agencies and their ability to interpret laws. Many now less speculating over the impact to ag. Well, Roger McEowen with the Washburn School of Law joins us now for some key takeaways for agriculture. And I know, Roger, last time we spoke, we just touched upon this. So a little background on the Chevron Doctrine. What sort of role did it play?
Well, this is a 1984 decision of the U.S. Supreme Court where they announced in the Chevron case what the doctrine was in administrative agency administrative rules. And basically, they set it up such that the hurdle was going to be very low for an individual that's challenging an administrative rule to get it overturned, because the Chevron Doctrine says that we're going to presume the agency is correct and any reasonable interpretation of the law will be upheld. It had to be arbitrary and capricious was the language for the court to overturn it. So that was a pretty tough hurdle for any challenger, including farmers and ranchers, to overcome in saying that their interpretation was incorrect.
Well, obviously, so many people felt that this was federal overreach. So when we look at areas of agriculture, do you see this being especially beneficial in certain places?
I do. This can touch on a number of areas, particularly labor law, although for agriculture, that won't affect a tremendous amount. On the agricultural side, probably more so on the environmental rules. We've seen the agencies struggle with the definition of what is a water of the United States, for example. That's been in everybody's mind for years. I had one case involving the swamp buster rules, and that case was tied up in the court system and the administrative system for 18 years, just because the agency said, well, we did what the court said, and the court said, no, you didn't. Go back and go through your process again. And you get in these endless loops of administrative rulemaking and interpretation. The one concern I do have here is, now have we shifted the presumption from the administrative agencies to the courts? And frankly, I'm not convinced that courts are much that better, even though the Chief Justice said that it's the court's job to interpret statutes. That's correct. But I've seen courts mess that up for years, too.
And that's going to be an issue, because we know that does not move quickly either. So this could pose some problems going forward. Well,
it's different. I think one benefit of this is that it sends a message to administrative agencies that you better tighten up your rulemaking process, and you better make a better effort to determine what the intent of Congress was when they wrote a particular statute, because, close is good enough in horseshoes and hand grenades, but it's not going to be good enough anymore with respect to the administrative agencies writing their rules. So I think from that aspect of it, it's pretty good, and that may influence the administrative appeal process too. And so that's good news for farmers. Ultimately, it kicks it to the courts to interpret what the language means, and that can be good or that may not be good. We'll see. We'll see if the courts are any better at actually doing their job than what the administrative agencies have been.
Yeah, we've been hearing, and that's something I think that I feel like may be a concern from some groups, that does this mean there's a closer inspection into some of these regulations and how that will play out? But it's going to be interesting to see.
Yeah, it's a good decision in my mind, because it does recognize the three-part system of government that we have. The executive branch executes the laws, the Congress writes them, and the courts interpret the law. That's the way it's supposed to work. So the message here to Congress, I think, is be sharper in your drafting of statutory language and leave less to interpretation. And then when there is a need for interpretation, it goes to the courts instead of unelected bureaucrats. I think that's all good. Then the bottom line is, will the courts do a good job in interpreting unclear statutes? And that's what I'm saying remains to be seen.
All right. Thank you so much, as always, Roger. Great stuff. Roger McEowen with the Washburn School of Law. Thank you for joining us, and happy 4th.